We frequently see correspondence between employers and employees marked as without prejudice. But what does this mean? Without prejudice discussions are a concept that is relevant to any legal dispute, and the idea is to encourage the parties to speak freely and honestly without fear of being held to their words later on. However, not every conversation between an employer and an employee that is labelled without prejudice can be considered as genuinely without prejudice. There are certain conditions that must be met for the without prejudice rule to apply. The most important is that there must be an existing dispute between the parties. This means that there must be some indication of a potential claim or legal action arising from the employment relationship. Simply raising a performance or conduct concern with an employee does not amount to a dispute. If the conditions are met, then the without prejudice discussion will be protected from disclosure in any future legal proceedings, unless there is evidence of fraud, undue influence, or improper behaviour by either party. There may be situations where an employer wants to have a confidential conversation with an employee about terminating their employment, but there is no existing dispute between them. For example, the employer may want to offer them an exit package because of a personality clash, a reorganisation, or a change of direction. In these cases, the employer may not be able to rely on the without prejudice rule, as there is no dispute to settle. This is why the concept of protected conversations was introduced in 2013. Protected conversations are conversations between employers and employees that are intended to end the employment relationship on agreed terms and that cannot be used as evidence in any unfair dismissal claim. There can be overlap with without prejudice discussions, but there are some key differences. These are: a protected conversation does not need there to be an existing dispute between the parties. This means that an employer can initiate a protected conversation with an employee, even if there is no indication of a legal claim. The discussion can only be excluded from evidence in an unfair dismissal claim. This means that if the employee brings any other type of claim, such as discrimination, whistleblowing, or breach of contract, they can still refer to the protected conversation in court or tribunal, unless that discussion is also covered by without prejudice protection. The discussion can still be admissible in evidence if there is evidence of improper behaviour by either party. Whether a conversation or email is without prejudice or a protected conversation will depend on the substance of the discussion as well as the label that is attached to it. They can be very useful for employers and employees to settle disputes or to agree terminations, but both parties should be aware that just putting without prejudice on an email or a letter does not make it so.